Well, good afternoon, everyone. Hopefully you can hear me okay. This is Lindsey Buchheit. I'm an attorney in Sergeant Bluff, Iowa. We're going to go ahead and get started with our presentation. We have an hour here to talk about ethical issues in estate planning. It looks like most of our attendees are online. I'm still getting quite a few popping up, so try and talk here for a minute, and hopefully we'll have everybody kind of on here by the time we dive into the meat and potatoes of this thing. Just a little bit of background about myself. I think this may be, well, it's probably the second or third time I've presented in Nebraska, but it always feels nice to present in Nebraska. I still consider that kind of my hometown. I'm from a small town of O'Neill, Nebraska, and then I went to law school at UNL, Nebraska-Lincoln. I went to undergrad at Nebraska Wesleyan. And for those of you who are sports fans, I am a huge Nebraska Cornhusker fan, even in light of the game last weekend. So it's kind of interesting being where I'm at in Sergeant Bluff, right by Sioux City. It's literally 5 minutes from Nebraska, South Dakota, Iowa border. So it's always kind of fun talking football around here. And in terms of practice, what I practice on primarily, I spend a lot of my practice on estate planning, probate, trust administration, things of that nature. And then I also do quite a bit of family law, which actually fits pretty nicely into the estate planning. Sometimes I tell people that I do family law, and the estate planners look at me and say, why in the world are you doing family law? And you know, my response is generally that family law, even though it can get kind of messy and have some Jerry Springer type cases, as many of you who know practicing as estate planners, those can be just as hairy, if not more, than divorce cases. So it kind of just depends on the case in terms of how messy those can be. But obviously as estate planners, you all know that we come into lots of interesting issues that involve blended families and sometimes conflicts between husbands and wives even, and sibling rivalries and all sorts of things. So they kind of go hand in hand. So for this hour, we're going to go ahead and talk about some of the ethical issues in estate planning. Obviously, we could spend days and days talking about all of the ethical issues. For today, I just tried to pick kind of the top three that I see in my practice the most, and we'll try and flesh out some of those areas. So the first thing that I want to talk about is identifying who your client is. And, you know, to a person who's not an attorney, that probably seems pretty straightforward. You know, you're going to know who your client is. But as many of you know, sometimes that's easier said than done. And so before you can identify who your client is, the first thing I wanted to mention is that you have to make sure that an attorney-client relationship actually exists. And so I've given you the restatement of the law governing lawyers, section 14, that talks about the formation of a client-lawyer relationship. And that states that that relationship arises when, one, the person who's the potential client manifests to you as the lawyer the intent that you would provide legal services for the person. And either you as the lawyer need to manifest to that person the consent to do so, which is probably the most common, right? I mean, someone comes into your office, they talk about their issue, and you say, yes, I'll help you with that. Well, then you have a formed relationship. But it's also important to note that as lawyers, we can also form an attorney-client relationship if we fail to say anything, if we fail to manifest the lack of consent, and we should know, or reasonably should know, that that person is relying on us to provide legal services. So with that, in terms of, and I've tried to kind of, throughout this presentation, I've tried to kind of highlight in yellow or in bright caps some practice pointers. I'll try and leave time for questions at the at the end of this, and if you have also any comments or things that you want to add, go ahead and put those in, and I can go ahead and you know, bring those into the conversation as time allows. So one thing that I think is a good practice point is in our office we routinely will send non-engagement letters to prospective clients, and with that, that's basically, for me, especially if it's anybody that I personally as the attorney talk to, I'm definitely going to want to have my staff send out a non-engagement, because then you always run the risk of, I feel like as an attorney, if I've talked to somebody, even if I say to them on the phone, you know, I'm sorry, I'm not going to be able to help you with this, and I hang up the phone, there's no real record of that. And so I always send a non-engagement, and I have a kind of a standard non-engagement that also says, you know, statute of limitations may apply, or time limitations may apply. You know, I'd recommend you contacting another attorney, that sort of thing. And that's just one of those CYA practices that I've been doing for quite some time. And so I'll generally send that out anytime that I talk to people. I've also kind of trained my staff, paralegals and secretaries who answer the phone, to, you know, verbalize that, to verbalize what it takes to actually create the relationship. So generally, to create the relationship, we're going to have a signed agreement stating that, stating who I'm representing, and then sometimes, you know, we may want a retainer or whatever, but that's all going to be, you know, said to them up front. And then even if I don't talk to the person, if my staff knows it's not a type of law that I handle, or we're not able to take any new clients or something like that, they've been trained to go ahead and send out a non-attorney client agreement or letter as well. And I just think that's a good practice. Sometimes it can be a little bit of a headache, but really once you get into the swing of it and the routine of it, it makes it pretty easy, and I think it can really save you from potential ethical claims in the future. So obviously once you have your client, you want to state in writing who your client is. And I think attorneys, I've been to a lot of conferences, and I've been to different ethics presentations similar to this, where they're talking about identifying your client, and I know some attorneys don't routinely do a signed written agreement. I'm one of those ones that I definitely want to have that, especially in my practice where I'm doing estate planning and family law. So my typical practice in my agreement is, and it seems really simple, but just even the very beginning part where you say, "Dear so-and-so," you want to make sure you have that person's name in there. And, you know, it's my understanding that you have hired me to represent you in this, right? You haven't hired me to represent your child or your spouse or anyone else. This is who I'm representing. And you also want to define the scope of your representation as well, what you're actually going to be doing for that person and what you may or may not be doing for that person. So I think it's just a good practice that any time that you have a client, have that in the client file. And the reason that's important in terms of ethics, obviously, is that in the event that, you know, you do get a claim against you, you have it in writing who you actually are representing, who you owe your duties to, and also you've outlined what you are supposed to be doing for them. Sometimes, obviously, people, once the case is kind of done and you think it's done, then they want you to do something else. You know, at that point, you're going to have to either expand your agreement or do a new one, clarifying what exactly you're supposed to be doing for them. So a common issue that I see come up a lot, I maybe see this once a month. A person will call into our office, you know, an adult child, and they'll call in and they'll say, "I want to make an appointment to meet with Lindsey to look at my parents' estate plan." And my staff has kind of been trained on how to handle this, but you know, I always want to know, first of all, and make clear, okay, so when we're preparing the attorney-client agreement, who is the client going to be? And generally, you know, that adult child will call in and they'll say, yeah, I want you to meet with my mom and I want you to redo her will or whatever. And I'm going to come along with her just to be there with her for moral support. And some of those are fine. I mean, I think it's a very normal thing, especially when, you know, mom or dad might be in their 80s or whatever, and maybe they already have a power of attorney in place, or they have their adult child on the checking account with authority to write checks and things like that just to help them out. And they maybe want their son or daughter or children there to kind of be there for moral support for the meeting. And you can kind of get a feel on the phone for that. Although, of course, if your staff is talking to them, you as the attorney don't necessarily know that. So sometimes you kind of go into that meeting blind. Other times, you kind of have to use a smell test, I think. You know I cringe, and I know my staff cringes when we'll get a call from somebody that says, well, you know, my dad's 90 years old and he's of sound mind, he's doing good, but he wants you to make this amendment to his will, and he wants to take out my sibling, and we just want you to draft that up, and then you can come here and he'll sign it. Well, that's always, you know, kind of a red flag for me. It may be completely valid and fine, and maybe that's what Dad really wants, and he is of sound mind to make that decision. But I then at that point need to go through some of these things with not only that child, that adult child, and explain to him that I'm not representing him, and that here's the things I need to do to make sure that, you know, if we make this change, that hopefully we can reduce the likelihood of a will contest and things like that. So so with that common issue, a couple practice tips. Whenever I have people in the initial meeting who, and you might have, you know, one child come versus all of the kids, and sometimes that kind of changes the dynamics. The way that I generally do it is I allow the family to come in with mom or dad, you know, whoever my client's going to be, and I'll meet with them and kind of exchange pleasantries and get to know the family a little bit, and then I'll start to dive into, you know, what mom or dad wants. And I'll start, hopefully they'll have brought their current will with them if they have one. We'll kind of review that, and then I'll start asking questions. And if the person who is responding is not my client, because a lot of times I might ask a question of my client, and then it's like one kid takes over and they're the one that's answering for mom or dad. That starts to make me a little uncomfortable, and so, you know, at that point I'll probably ask them to step out, and to make it so that it's not so uncomfortable for everyone, usually before I start to go into any of the real issues of it, I'll explain to them, you know, the purpose of the routine of what I generally do, and that's that I'm going to want to meet with mom or dad, you know, my client alone for at least part of the meeting. And I'll explain to them the reason for that is, you know, I have a duty to protect their confidentiality. I also want to make sure that they're able to speak freely without any undue influence or to feel awkward or anything like that. And I'll kind of just put the blame on myself so that the family doesn't feel awkward about it, or so they don't feel strange that I'm asking the child to leave. Because, like I said, sometimes it's completely fine. It'd be fine if they sit there, but I just do that for everybody, regardless of how, you know, legit it seems. And in that way, I can just say that, you know, honestly to everyone, that this is my practice and this is how I do it, and that's why. So, but if I am asking questions, sometimes I might ask questions, and the parent, you know, it becomes very clear to me that they're completely of sound mind, they're independently speaking for what they want and things like that, and I'll let the kids sit in for that for a while. But I'll definitely ask them to leave at some point, just to kind of review what we talked about, review what they want to have happen, and make sure that's their intention. And then obviously when we sign, and I'll usually explain this part to the entire family at the initial meeting. I'll explain, you know, when your mom and dad, when you guys come back and they're here to sign this, we'll have a notary and we'll have 2 witnesses here that we're going to provide for you. neutral witnesses. And if you want to drive mom or dad to the appointment, that's fine, but I'll have you sit outside while, sit out in the lobby while we go through and review the will and sign the will. And so my practice is just not to have anyone else in the room other than the witnesses, the notary, myself, and the client, especially when we're signing. And then that way when they come back, they're prepared for that and they understand that that applies to all cases. So why is that all important? Again, and I think when you're explaining who your client is to the family in that setting, I think confidentiality, kind of see that throughout this hour is a big duty that we know that we owe our clients. There's also other duties, of course, we have, like duty to disclose and duty of loyalty, all sorts of things. But duty of confidentiality is one of those that is huge, and especially in the estate planning realm, that can get pretty tough sometimes, especially, when you have a client who might be mentally impaired or incapacitated, things like that, which we'll talk about here in a little bit as well. So I wanted to give you just a little bit of law on that because I know this is an issue for the majority of us. So Nebraska Court Rule Professional Conduct 3-501.6a says that a lawyer shall not reveal information relating to the representation of a client unless the client gives informed consent. And we'll talk about informed consent in a little bit. To me, informed consent, at least initially, if mom and dad is bringing the child, the adult child in that example, to the meeting and they're saying, yeah, I want them to sit in with me, yeah, they're giving some informed consent. We need more than just a verbal, yes, you can talk to them, and we'll go through that in a little bit more detail. But at least that gives me a little comfort that they do, they do want their children to know some of these things. Obviously, when I talk to the client aside, I'll reiterate that, our relationship is confidential and what you tell me is confidential. And even if you're going to give me written informed consent to talk to your adult child about this, there might be some things that you tell me that you don't want me to disclose. So you've got to have that conversation. Then obviously the big thing that comes up in the estate planning context is you represent somebody, you do their will, and then they die. Well, okay, so then you presumably might be doing their probate or their trust administration or whatnot, and so you're representing the estate or the trust. And you have to remember that your duty continues post-death. So, especially a lot of people who do trust like the privacy aspect of it, and you might have set up a trust for somebody who told you things. For example, they may have told you about infidelity, an illegitimate child, all sorts of things that they don't want anyone else to know. And so that duty, as a general rule, continues even after they die, and it's your job to make sure that nobody finds out. Again, there are some exceptions which we'll talk about, but as a general rule, just remember that once that person dies, you still have a duty to keep those things confidential. So in that context, when you have a client, you've done their estate plan, and then they've died, you want to make sure at the very first meeting, and of course it's interesting at that point because you're meeting with people that aren't really your client. I generally, and I think attorneys kind of vary on this, I guess my feeling is that if I have drafted a will or a trust for someone and they pass, and then the executor or trustee asks me to help with the trust administration or the probate, I represent the estate, the decedent still, right? That's who my loyalty is to first and foremost. And so at that meeting, even though obviously my client is not there, I'm explaining to the decedent's loved ones and the executor and fiduciaries that, and I'll usually bold this also in bold print in my attorney-client agreement, and I'll specify, rather than dear to the decedent, I'll state to the executor, and I'll state, you understand I represent the estate of your mother or your father or whoever it is, and I'll be very clear about who I'm representing. And I'll talk about this duty of confidentiality as well, and I'll have a paragraph in there too that says, so, I'm looking out for the best interests of the estate. My job is to make sure that what we drafted is enforced, and that means that even though I have a duty to the executor, I have to try and prevent the executor from breaching any sense of fiduciary duty and make sure that they know what things need to be filed and when and things like that. That if the executor tells me something and it needs to be disclosed for the benefit of the beneficiaries or the estate, I explain to them right during that first meeting in front of everybody that this is a two-way street, and how this kind of interplays and how it can get complicated. But that duty of confidentiality doesn't necessarily exist between myself and the executor or myself and the beneficiaries, to a certain degree. And so I'll have that conversation. Again, I have those parts bolded in my initial attorney-client agreement. I also then follow up with a letter to the fiduciaries, the executor, the trustee, and then also the beneficiaries, and I reiterate one more time to all of them, here's kind of the process of how things are going to go, and here's the things I'm going to need for you, and then I'll kind of have another blurb in there. Again, this is who I represent, and the duty of confidentiality, and I'll have a little snippet about that. This is a hard area, even though we can talk about the rules and how this generally works. It's still pretty hard in practice, and I still, I'm going on my 10th year of practice, and I still have things that come up, and I'm sure some of you who have been practicing 20, 30 years still have issues that come up that are difficult, that cause you to have to kind of pause and look at the ethics rules before you make a decision on how to handle it. And as an example, I was looking at the ABA model rules, and even those are inconsistent, where it states in one part that under one view the client is the fiduciary. So, and then under the other view, which would be, so they're saying basically in one part of the ABA model rules, they're saying, okay, client dies, you now, lawyer, owe your duty to the executor or the trustee, and that's where your duty lies. But under another view in the ABA model rules, it talks about we owe it to the estate or the trust, including the beneficiaries. So again, and it does state in the rules that you have to make clear the relationship to the parties involved. One thing to watch on that, just that I've kind of noticed in practice, is you'll want to make sure that when you're doing your pleadings in a probate, for example, or maybe a trust administration, at the bottom of your caption where you say attorney for so-and-so, make sure that that's consistent with what you're saying as well. So attorney for the estate, or attorney for the trustee or executor, whoever that is. Mine generally says attorney for the estate because that's kind of what I do in most of my cases. Okay, so just to kind of cap off this idea of confidentiality, I've also cited for you the Nebraska Rules of Professional Conduct 3-501.18b. A lawyer also who has had discussions with a prospective client shall not use or reveal the information learned in a consultation except as Rule 1.9 allows. So there are exceptions, but generally, again, just remember, in terms of identifying your client, and particularly with regard to that duty of confidentiality, I know I do consultations sometimes, and I'll state, and I'll have them actually sign an agreement just acknowledging that I am not representing them past that initial consultation. And so in that agreement, I'll state, you've hired me just for this 1 hour, and I've given you what advice I can, but we are not taking you on as a client going forward, and I have some other language in there, and But even with that, I still have a duty to maintain the confidentiality of that client, even though I've only represented them for an hour or whatever it may be. You know, they told me something, you know, I can't use that or take on another client where that could be a conflict of interest, which we'll talk about here in just a second. And then the other one is 3-501.18 subsection C that says, subject to that first paragraph up in B, a lawyer shall not represent a client with interests materially adverse to those of a prospective client in the same or substantially related matter if the lawyer received information from the prospective client that could be significantly harmful to that person. So this is reiterating that if somebody comes in to me as a prospective client, or say I'm just on the phone and they're inquiring about, you know, my services and an issue that they have, if I talk to them, and this is one of the main reasons that I actually don't like to talk initially to people, prospective clients that call. And I've wrestled with this in terms of what's the best way to do this, but this is ethically, I guess, the best way that I've found. I used to just take calls from people that called, and I'd talk to them. Then it got to be kind of a matter of, first of all, it takes a lot of time sometimes. It's hard to get them off the phone. You know, they'll talk for 30, 40 minutes about certain issues, and it's pretty hard not to, you know, give any advice during that. And then, of course, that issue comes up too ethically. And so my practice, generally speaking, every once in a while I'll make an exception, but I mean, 9 times out of 10, I'm not going to talk to a prospective client. I'm going to have them talk to my staff. They've been trained kind of what to ask, what to say, things like that. Just get kind of the basic information. We run a conflicts check internally, make sure there's no conflicts, and then I'm ready to meet with them, and then I'll have the attorney-client agreement, whether that's just for a consultation or whether that's going to be for, you know, something going forward. And I may not know that until after that first meeting, but regardless, we're going to have that meeting and identify, okay, here's who I'm representing, and I have to make sure that if I have talked to somebody and there could be a potential conflict, and then obviously I'd have to disclose that right away as soon as I realize that conflict is there, and send them on their way to another attorney. So just to summarize kind of the practice tips for identifying your client, verbally express it. I don't think it hurts at all, especially in a estate planning context, especially when we're talking about probate and trust administration when your client is deceased. Verbalize it and have that very candid conversation. I think you actually earn quite a bit of respect from people, for those involved, by doing that. Plus, it obviously helps cover your butt ethically. Reiterate it in writing, who you represent. Make sure it's in writing. Make sure that make sure it's signed. And then, as things come up over the course of the case, you know, that might kind of cause you to pause and review the attorney-client agreement if you have to, and the ethics rules before speaking to anybody else about the client and their case. And then, like I said, there are people that are going to give you informed consent, and that's fine. Just make sure you obtain that in writing and include a provision that they can revoke that, but they need to revoke it in writing, because you don't want an instance where they give you informed consent to talk to their adult children about their estate plan or something, and then, you know, maybe they call you up and say, or call up your staff and say, make sure you don't, you know, make sure Lindsay doesn't talk to so-and-so anymore. We had a falling out, and if that either doesn't get relayed to me or whatever, I want to make sure that I have this informed consent in writing that says you can revoke it, but I need it in writing. Okay, so switching gears here a little bit, talking about conflicts of interest. Once you've determined who your client is and who you're representing, you have to consider whether there's a conflict. And there could be an actual conflict of interest that exists, and there can also be a potential conflict of interest that could exist in the future. So again, as I mentioned, we, as I think a lot of firms do, we run an internal conflicts check. Some people have real sophisticated software for that. Others have, you know, whatever system internally they do. But regardless, I definitely recommend having something set up where you can run a conflicts check And a key thing with that too, it's not just always the person that's calling, or your current or your former clients that you've represented, but other persons as well. And when I say that, this really comes up, I guess, in, like in family law, for example, when I'm doing a divorce, I always I'm always thinking about who are the potential witnesses in this case. And so if it's a divorce and the other party maybe already has a boyfriend or girlfriend, I want to know who that person is, so I can put them in the conflicts check system. Or throughout the case, even in the estate planning context, all of a sudden you might think that you're probating a will that's going to be very straightforward, but then out of the woodwork comes the illegitimate child or the long-lost relative or whatever. You want to get them in the system just so that pops up in the future if you learn certain things about that person that could present an issue for future cases. So I really recommend that in your conflicts check system software or whatever you have set up, that you consider, and just not you, but train your staff to really ask those questions and put into the system not just the clients that you've represented and the opposing parties, but also other persons who have served as, for example, witnesses in the case. And you want to keep in mind that in estate planning, a conflict may not exist just with whom the attorney is representing, but in the action sought to be accomplished by the attorney services. So, for example, husband and wife. That's a huge issue, which we're going to talk about in a little detail here in a second, that I see in the estate planning context. There can be something between a parent and a child, which we talked about, siblings, all kinds of rivalries that can happen there. Parents may want to disinherit some children but not others. And then, of course, blended families, which is becoming more and more common over the last, couple decades, and probably more so even now. So the idea with conflicts of interest in the estate planning context between spouses and couples, and I originally had just spouses on here, although recently I've done a couple estate plans for people who were in, I guess what you'd refer to as a committed relationship. They don't necessarily consider themselves common law married, but they, maybe have a child together and they maybe want to leave their estate to the other and things of that nature. And so for ethical purposes, I still kind of treat them, in my mind, as spouses in terms of the potential conflict of interest that could occur. So I've given a couple examples of what I see, and maybe you guys have seen other things as well, but especially with couples. One example I've seen is when the husband and wife, they meet with you and they discuss your will. You have a very normal, straightforward conversation about this is the estate plan we're going to do. They leave, they sign the agreement. However, only the wife comes back to sign the will. And the husband never signs the will. Maybe he just got busy or whatever. Well, that's not a huge deal right then and there. It's very clear that you represent both the husband and the wife and you owe all of the duties to each of them. And I actually have one of these right now where it's been, I think, over a year now where the wife hasn't come back to sign her will. And in fact, she was never even in the initial meeting. It was just I met with the husband and it was just a basic will and powers of attorney, and so I did his and he signed, but the wife never came in, and so we've been sending her letters saying, okay, you've got to get in here and sign your will, and I've obviously got to meet with her and go through it with her. But the ethical issue really comes up when, what if, in that instance, I've signed it for the husband, but then say the husband calls me a year later and says, well, I want a divorce now. Can you represent me on that? Well, technically I haven't met with his wife, and her will is her will and his will is his will, so I suppose there is a gray area there, although my feeling on that would be no. I would just say no, I wouldn't represent them because I had a signed agreement, even though husband was the only one that signed it, I probably wouldn't go down that road. Others may feel differently. I tend to think if there's even a possible conflict, I'm just not going to touch it. But those are the sorts of things that can happen. Or even if the husband comes back and says, well, I want to change my will now, and I want to leave less to my wife. I want to leave maybe just a third to my wife and the rest of it to my other child or something. Okay, well, I have a duty to disclose. Do I have to call up wife and say, hey, your husband made this change in his will? Technically, maybe I do. Those are the issues that can kind of come up. So another one is when a married couple or a committed couple meets with the attorney and both parties sign their wills. And then again, later, one spouse might call the attorney and say, hey, I want to change this. And I don't want you to tell my wife about it because she might get kind of mad that I'm changing the order of executors or something like that. Well, again, you have a duty to disclose. And my feeling is you would have a duty to talk to the wife about that. And obviously, before you did that, you'd want to explain that to the husband. And on the practice tip, I think the thing that can really save you in a lot of those cases would be something that I started doing a couple years ago. And to be honest, I haven't been real consistent doing this with every married or committed couple. I tend to use this just for people where like if it's a blended family, or if I think that based on my conversations with them, you kind of just get a sense for it. If there could be a conflict down the road, where they both don't really kind of agree necessarily on what they want in their plan, things like that, I'll have them sign a waiver. And it's a very detailed waiver. If any of you want a copy of what that looks like, feel free to email me. I'll shoot it your way. As an example, there may be better ones out there, but it's tend to have worked for me, and it's good because, again, I will have that discussion with them up front and just say, look, you're a married couple, and sometimes issues can arise, and I'll explain the attorney-client privilege and how that works, and say, because I'm representing both of you, you need to understand that here's the sort of thing that could happen, and I'll give them examples of what happens, and I've had that happen, and I might give real-life examples so that they don't feel awkward about it. And then I'll have them review it, and then they can take it home if they want and chew on it for a while or whatever. Or some of them will just read it, and then if they feel comfortable and they sign it. But I think that's a really good practice to do. And honestly, I want to try and get myself to where I just do it for every couple that I'm representing. So that's one of my goals for 2017 is just to do it routinely. So I can just tell everybody, hey, if I'm representing joint people, I do it for everybody. And then another example would be both spouses meet with the attorney, but as the discussion moves forward, it's clear that spouses have different estate planning goals. So there, I think as long as you're in the first meeting and you haven't really learned anything, earth-shattering or something that's going to be detrimental to either party, it might just be in your best interest to say, it appears that you guys have very different ideas of what you want in your plan, and maybe it's best that you each have a separate attorney, to do your plan, and maybe just handle it that way. Or at the very least, that's when you whip out that waiver for the potential conflict of interest and have that discussion then, and say, if I'm going to be able to represent both of you, here's kind of the issues that could occur, and I want you to understand that if one of you calls me and tells me you want this later on, or you want me to change that later on, I have a duty to disclose it to your wife or your husband or your committed partner or whatever it may be. One other example that I had thought of, I don't have it on the PowerPoint, but I did have a case a couple years back where husband came to me and fairly significant estate, maybe $15 million or so, and seemingly happily married. And he wanted to meet with me alone first before bringing his wife into the meeting. And so that first of all kind of struck me a little strange, but I said okay. And met with him, and things were fine, and he was, going to do like a Q-tip trust where, it benefited his wife during her lifetime and definitely wasn't cutting her out in any way. That all seemed very normal how he wanted to set it up. But he wanted to make sure that she didn't know the extent of their assets. And his reasoning for that was, well, I don't want her to, know it all, and then she'll want to start spending it all, and so on and so forth. And I had a very candid discussion with him and said, I get where you're coming from, but I said, as an attorney, ethically, if I'm going to represent both of you and I'm going to do a will or a trust, for both of you, I can't hide those things. I have a duty to disclose. If your wife asks me certain things about this, I'm going to have to tell her. And so we had a long conversation about that. And then the next time we brought the wife in, and I had just prepared him, and he got to the point where he kind of just understood that was the way it was going to have to be, unless he wanted, he could have went to a different attorney, or he could have went to, or had her go to a different attorney or whatever. But he then was comfortable with it, and things worked out just fine. But with that, you definitely, again, I think you just need to kind of use the smell test and have your antennas up in those situations. Rules, a couple other rules I just wanted to point out with regard to conflicts of interest. The first one there on your screen, 501.7a, a lawyer shall not represent a client if the representation involves a concurrent conflict of interest. And that exists if the representation of one client will be directly adverse to another client. So again, especially in the husband and wife context, you can't represent both people if husband or wife or whoever calls you up later on and says, I know you represented both of us, but I want you to change my will to do X, Y, and Z. You have to withdraw from it and have another attorney do it or something at that point. And again, under 501.2 subsection A, a lawyer shall abide by a client's decisions concerning the objectives of representation. And that just reiterates why you can't do these things in the estate planning context, because you are taking on two clients when you're doing a joint representation for a couple. And then I've also listed the ABA model rules of professional conduct. I refer to these a lot I practice in Iowa, Nebraska, South Dakota, and all of the ethics rules are a little different. But I think the ABA model rules are always good just to pull out to see generally what they expect of attorneys. And, that states, again, pretty similar to Nebraska, a lawyer shall not reveal information relating to the representation of a client unless the client gives informed consent, which, again, we'll talk about that. A lawyer may reveal information relating to representation of a client to the extent the lawyer reasonably believes necessary. So with that, as we're talking about husband and wife and you're representing both of them in an estate plan, if husband tells you something that doesn't affect the wife's estate plan, it's not going to adversely affect her, then you have a duty to keep that confidential, I think. You don't have a duty to disclose that because it's not affecting her case. But obviously, if he tells you something that's going to affect her plan, then you would have a duty. So again, you can reveal information to the extent you reasonably believe it's necessary. And then the lawyer also has to make reasonable efforts to prevent the inadvertent or unauthorized disclosure of or unauthorized access to information relating to the representation of the client. When I see that, I think automatically of trusts because they are a private document. They're intended to be private. So, even with that in your estate plans, we have rules imposed upon us as attorneys to make sure that they are, kept in a secure place, fireproof lockbox, things like that, so that later on, even remember that duty of confidentiality continues post-death, so that even when the executor or the trustee comes in later on after mom or dad has died, we want to make sure that if there is something that the client told us that they wanted us to make sure was confidential, and it's not something that's necessary to be disclosed for purposes of rendering your services, then you've got to make sure that those things are locked up in a way to make sure that that fiduciary never gets a hold of it or sees it, and those sorts of things. So okay, the next one, the exception, again, as far as when you can disclose, one of the exceptions is if you get informed consent, which we've talked about today. And when a conflict of interest arises, obtaining that informed consent can sometimes allow you to continue representing the client. So I talked about the example of the husband and wife waiver when you're taking on, dual clients initially. That's just one example. It might also be something where there's a potential conflict, and then that comes to fruition and actually becomes a conflict during the case, and then you have to approach both parties and say, okay, here's the conflict that's arisen, here's an informed consent, you can choose to sign it or not. If they don't, obviously you've got to get out. If they do, you can continue. But a couple of things when you're doing that, make sure, look at Nebraska Rules Professional Conduct 3-501.7, and when you look at that, if you go through the comments, there's quite a few comments. If I remember, there might be 30, I think there's more than 30, but the comments are actually pretty instructive, and if you look at the comments 18 through 22, that's where it's going to talk about informed consent and things that are necessary with that in that section. And essentially, what one of those comments says is that when a client agrees to a proposed course of conduct after we as the lawyers have communicated adequate information and explained the material risks of and the reasonably available alternatives, then they can give informed consent. And so to take that kind of a step further, you have to remember it's not just a sentence on a piece of paper that says here's the conflict that's arisen, you have the right to sign this or not. You have to specifically describe to them verbally and in writing the existing conflict and then the risks or the future conflicts arising, and make sure that they understand what they're agreeing to. So in mine, I always make sure that I give them the right to say, you have every opportunity to take the time, as much time as you need, and leave the office and whatnot and come back, a few days later and sign this if you want, or go review it with another attorney if you want. I mean, whatever they want to do. They have to make sure that they understand what they're signing. And then if there are foreseeable risks, you have to spell out to them explicitly what those risks could be. So just giving them a blanket, there could be future risks, is not sufficient. So what I generally do is I give them an example, and when I'm talking to them, I'll say, okay, here's an example, and here is what I have seen in my practice that actually has happened. And so this does happen, and this could happen, and are you okay with me representing both of you if that happens? And make sure that you have that actually written in the document itself. So more on informed consent. If the lawyer has obtained the client's informed consent, the lawyer may act in reliance on that so long as it's confirmed in writing within a reasonable time thereafter. If you look at 3-501.0, that's where the terminology is for this section. And subsection E actually defines informed consent for you. So that's a really good place to look, especially if you're wanting to draft one of these, to make sure that you're hitting all of the requirements. Again, it has to be confirmed in writing. Confirmed in writing means that it has to be either signed by the client or, which is my preference. I mean, that's what I always do. But the other thing you could do is you as a lawyer can confirm it in writing, and you can say, okay, you have given me authorization to represent this person despite the conflict of interest, so on and so forth. And you can do it that way too. I think the former way is better just because it's their signature. Seems to be a little bit more persuasive for me. And then under comment 20 of that 501.7 section we talked about, the requirement of a writing does not supplant the need in most cases for the lawyer to talk to the client. I think especially newer attorneys that, you know, maybe they find it difficult to talk to the people, or even it can be hard for you know, the veterans out there who have practiced a long time, just depending on the dynamics of the people that they're talking to can make it pretty uncomfortable. But it's not enough just to hand them the form and say, hey, there's a potential conflict, read through this and sign it if you want. That's not enough. You have to have the actual conversation with them. And honestly, again, I think that you gain a lot of respect by doing that as well, just you know, as a topper on that. And I think it's good for you too, because you might in that discussion realize that you don't necessarily want to take this on. You might just say, you know what, this is going to be really messy, and I think you might be better off just parting ways and, you know, each of you having your own attorney. So best practice: explain the risk associated with the conflict, outline any reasonable alternatives, give the client a reasonable opportunity to weigh those considerations before consenting. All right, so our last part is on handling clients with diminishing mental capacity. I've given you the rules of professional conduct sections there, 501.14. That's where you're going to want to look for that. Under subsection A, keep in mind that it says when a client's capacity to make adequately considered decisions with a representation is diminished, the lawyer, as far as reasonably possible, needs to maintain a normal client relationship with the client. So even if you have somebody with diminished capacity, you're going to treat them just as you would any other client, as far as you can. And we'll talk about obviously the exceptions with that, because sometimes it's just impossible to, you know, to do it exactly as you would with somebody that doesn't have diminishing mental capacity. Under subsection B of that section, when the lawyer reasonably believes that the client has diminished capacity and is at risk of substantial physical, financial, or other harm, unless action is taken and cannot adequately act in the client's own interest, the lawyer may take reasonably necessary protective action, which would include consulting with individuals or entities that have the ability to take action. So, you know, a common thing that I see is somebody in a nursing home. We have, where I'm at, there's a nursing home just up the street, so a lot of times I'll get calls to come in and meet with people there. And, you know, if it's somebody with dementia, and I'm maybe even just the onset of dementia, you know, so it's just kind of diminishing mental capacity. They may not, at least at a certain point in time, because, you know, sometimes those people can be pretty good and understand things very well at certain times of the day, but they might get confused other times of the day and whatnot. And so depending on the circumstances, it just kind of depends, you know, how you're going to handle that. And then if I think that they're going to, you know, adequately think that they're going to harm themselves either physically or financially, which is what I see more often than not, then I can go ahead and talk to somebody that I think can help protect that. But I'm only going to disclose the absolute necessity. So it's not like I can just go and disclose everything about their case. I'm only going to disclose what I absolutely need to protect them. So the ABA model rules, again, I like to look at those on these ethical issues just to see what they have to say. 1.4 is their code of conduct there, and it says when a client's capacity to make adequately considered decision in connection with the representation is diminished, the lawyer shall maintain a normal client relationship, just like in Nebraska. Same thing too, they can take necessary protective action if they think that they're at risk. And information relating to the representation of a client with diminished capacity is protected by Rule 1.6. So you can look at that for future reference if you find yourself representing folks with diminished mental capacity. A couple of Nebraska citations for you. One is the Ethics Advisory Opinion for Lawyers, number 91-4. It states that an attorney may disclose confidential attorney-client communications to the extent necessary to protect the best interest of the client when the attorney believes that the client is reasonably mentally incompetent. One thing that I do is if I think that the client, generally if I have a client who's, you know, in their 90s or something, first of all I'm going to ask the adult child that, you know, might be calling in for them, well, are they of sound mind? And sometimes it's yes, you know, they're really with it. Obviously sometimes they drive themselves to the appointment and they're more with it than I am, so I can tell that, you know, I have no question that they're good to go. But others, you know, they might be very quiet. They maybe have, you know, they can't drive anymore, and it's kind of up in the air. Like you just can't tell. Maybe they're just a quiet person, or maybe they're just, you know, generally losing a little bit of memory, but still obviously have testamentary capacity. And so that's a huge reason why you want to meet with those people alone, just like any other client. You want to meet with them alone and do an internal test for yourself to see if you feel comfortable that they have capacity, and figure that out first and foremost for yourself. And then if you feel like you don't know for sure, then, you know, you might ask for a doctor's note. You know, you might ask their family, you know, can you get me a doctor's note from somebody? Or maybe maybe they've already been to the doctor and maybe they can provide you with a record or something like that. Nebraska Rules of Professional Conduct 501.14 subsection C. Information relating to the representation of a client with diminished capacity is protected by Rule 1.6. Again, that just reiterates the lawyer has implied authority under Rule 1.6a to reveal information, but only to the extent necessary to protect the client's interests. So again, keep in mind, you have an exception there, but it's only to the extent that you need to protect the client. Client's testamentary capacity. One possesses testamentary capacity if he or she understands the nature of his or her act in making a will, knows the extent and character of his or her property, knows and understands the proposed distribution of the property, and knows the natural objects of his or her bounty. I've given you some citations there on the cases in Nebraska. Keep in mind, such a capacity is tested by the state of the testator's mind at the time the will is executed. So again, some people with diminishing mental capacity may be better equipped to, you know, pass that testamentary capacity test at certain times of the day or under certain conditions rather than others. I know we're about out of time here, so I'll just kind of run through these next ones quickly here. Just a good rule of thumb, I think, especially when you are dealing with somebody that does have diminished capacity or somebody that you think may have that. Ask these questions. I even know of some attorneys that will ask this of every single client, which I think is great. You know, it takes a lot of work, but it's also a good routine, I think, to have. And, you know, ask them these questions and have the witnesses obviously in there when you're asking these questions. You know, do you know what you're signing and its purpose? What assets do you own? Do you understand the executor and the trustee will be dividing and distributing your property by, and then just kind of summarize, you know, what that will or trust says. And then maybe just ask them, you know, can you name your close family members? And who are your beneficiaries under this estate plan? So practice considerations, especially in cases where a challenge is likely. You want to consider these things, and these are just some examples that I had thought of. You may have other examples, and if you would be willing to share those, or you want to send me an email or something, I would love that. But a note to the file, and that's generally, I do that very consistently for a lot of these folks regardless, or possibly in rare situations a videotape conference. I have never personally videotaped a will signing. I know of many people that have. One case that I found that actually illustrates where the attorney did that, because he kind of had foresight, knowing that, wow, this is going to be a contest. And it worked out for him when a couple of the kids tried to contest Mom's will, 10 years later. That case is the estate of Klinger. It involved, I think her name was Mary Ann, if I remember right. Yeah, Mary Klinger. And the 2015, it was actually 2011, it got appealed. But the case citation is 292 NEB 237. And it's actually a really kind of a fun read, and it talks about how they videotaped her signing even 10 years before her death. And then she did another will a month before her death, and they videotaped that one as well. And the attorney even said during the trial that I did this because I expected some sort of will contest. So I generally do a note to the file for sure. I also have a letter from the physician, even initially, like before generally I even draft the plan. And sometimes you may or may not get that from the physician. It just depends on the physician. I also have my witnesses take detailed notes if it's at all questionable about whether or not they're understanding things. If they're on the hospital bed and they're having a hard time verbalizing, I definitely want witnesses taking detailed notes about the questions that I asked and their answers and how that process went. I underlined in all cases you want to make sure you have a routine for signing and ensure your client has read and understands the estate planning documents. So again, I kind of talked about what my routine is on that. I encourage you to get comfortable and set your own routine. And I think that's really important because if you ever have an ethical complaint about, did your client have signing testamentary capacity or whatever, you don't want to be in a situation where you say, well, this is the first time that I ever did a videotape of this person, and if I've never videotaped anybody else, that's going to kind of send a red flag to, geez, maybe I really didn't know if this person had the testamentary capacity at all. Whereas if you routinely do videotapings for people where it's kind of up in the air, then that seems, much more legit and maybe doesn't give as much leverage to the person who's contesting the will. So again, just kind of have a routine and stick with it. And of course you want to have the required self-proving language and the attestation from the witnesses. Probably most of you know that, but there is a statute when you're doing the signing of a will. You got to make sure that you have the two witnesses, the notary, and then there's certain language under the statute we want to make sure we have that says that they, were not unduly influenced and they were 18 years of age of older and all of that stuff. So, and then also, again, time the signing when the client is most aware and alert. Again, sometimes clients, especially if they're in the nursing home or assisted living, you might want to talk to their care providers and their family and say, when is mom or dad most alert? A lot of times for me, I find it's after their naps. It might be, 1 or 2 in the afternoon. If they're medicated, find out, what medications or if any medications make them, more foggy than others. And maybe they can even, I've had nurses say, what, we'll wait to give her medication until after the signing. And as long as that's medically okay, then that's kind of a nice thing to do. And at the end all be all, just remember a lot of people will try and call and have you do a rush minute job. Mom or dad is dying. I know I've had several of those. Kids call and they say, I want you in here to, get this done. And if you can do it, that's great. But again, you've got to make sure they have the capacity to do it, and don't, jeopardize your license or the stress of having to deal with an ethical complaint by not taking the time to make sure that they have the testamentary capacity to sign. So always err on the side of caution, I think, with that. And 2, if it's something that's not a huge rush deal too, and you say, I don't think they have the capacity to do it, there's always the option for a guardian ad litem, guardianship or conservatorship or something like that. Of course, I know in Nebraska, with the rules on that, it's made it a lot more difficult, but you're a lawyer and their problems aren't necessarily your problems, because we're dealing with problems for tons of clients. And again, I think you earn a lot of respect from people just by kind of sticking to your guns and following the rules. And so with that, I'm over time here. Didn't really leave any time for questions, but if anybody has any and wants to send me in, let me know. Again, if hopefully my email address, I don't know if that was published on the thing, but if not, you can email me at lindsey@buchheitlaw.net, and if you do a search in Sergeant Bluff attorney, I should come up there too, so you can find my contact information that way if you are looking for anything. So that's all I have, so enjoy the rest of your day.